Hi guys, let's talk about how to protect your rental properties from lawsuits. What if a single tenant slip and fall could wipe out your entire real estate portfolio? Now that may sound like fear-mongering, but it's a story I've seen play out for my clients over the past 34 years, more than I can count. Landlords getting blindsided by lawsuits and losing it all. Not because they did anything wrong, because they didn't protect themselves. If you own rental property, or plan to, this might be the most important video you watch this year. I'm going to show you how high net worth investors protect their rental portfolios, not just with LLCs, but with one of the strongest legal asset protection structures in the world, combined with a little-known strategy you'll be able to understand as soon as you're done watching this video. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners, the nation's largest asset protection firm, and I've been protecting real estate from lawsuits for 34 years. Subscribe if you want real legal strategies to protect your wealth. No fluff, no gimmicks. Let's dive in. Point number one, the hidden danger of real estate. Now, rental real estate is one of the best vehicles for building your wealth. You get cash flow, appreciation, and tax write-off. What's not to love? But there's a hidden danger most investors don't talk about: lawsuits. According to the National Center for State Courts, landlord-tenant cases make up a substantial portion of civil litigation. The top issues? Personal injury claims, wrongful eviction, mold exposure, and habitability complaints. And insurance isn't a silver bullet. The American Bar Association reports that 61% of property owners involved in litigation said their insurance didn't fully cover their legal costs. So here's the reality. If you're holding property in your personal name or under one LLC, you're walking around with a legal bullseye on your back. That brings us to point number two, a true story: how one investor nearly lost it all. Let me give you a real example. A client, let's call him Tom, owned 8 rental properties in Florida. They were all under one LLC. One tenant tripped over a cracked tile on a rainy day and sued for negligence. Sounds minor, right? Well, the lawsuit named the LLC and Tom personally. The plaintiff's attorney claimed Tom was negligent as the managing member and argued to pierce the corporate veil. They froze the LLC's bank account. His rent payment stopped. He had to sell one of his properties just to cover the legal fees. And all of this stemmed from one minor injury on one property. And this is the kind of thing that wipes people out, but it's also 100% preventable with the right structure in place. So here's point number 3, the first line of defense: a land trust for privacy. So the first thing we do is get the property out of your name and into separate land trusts. Now, land trusts give you privacy of ownership and great flexibility. Benefit number 1 of using a land trust is that it helps you avoid the mortgage due on sale clause. Now, the Garn-St. Germain Depository Institutions Act of 1982 says that if you own a property that consists of between 1 and 4 dwelling units, you can put a property into a land trust as long as you're a beneficiary, and the bank cannot force you to suddenly pay the loan in full for changing the title like they can in certain circumstances if you put it directly into an LLC. Plus, with a land trust, you can sell the property, but you don't even need to change the title when you do that. You simply assign your beneficial interest in the land trust to the new buyer instead of changing the title, which could potentially save you thousands of dollars in closing costs and transfer fees. Point number 4, the second line of defense: LLCs done right. Now, before we get to the advanced strategy, let's talk about LLCs, or limited liability companies. They are your second layer of defense, but only if you use them right. So here are the fundamentals. Change the beneficiary of your land trust to an LLC. Once we have each property in separate land trusts, we have a second piece of paper called an assignment of beneficial interest. Now, on this document, clients will name their LLC and change the beneficiary of the land trust to the LLC. So they assign that beneficial interest in the land trust over to the LLC. And that way, when there's a lawsuit on that property, the LLC absorbs the liability instead of them personally. So one property per LLC. Don't put multiple properties into one LLC, because that's like putting all of your eggs in one lawsuit basket. If something goes wrong on property A, you don't want properties B, C, and D dragged into that lawsuit. Next point, choose the right state. Now, for real estate, we typically set up LLCs in the state where the property is located. Since the real estate is subject to the laws of that state, we really see little benefit in using out-of-state LLCs to own real estate or to be the beneficiary of the land trust that owns the real estate. Next, holding company. We set up a holding company, own all of the LLCs, and collect the rent on all the properties. Now, we don't usually set up bank accounts for each of these individual LLCs. Instead, we set up the holding company that has the bank account that owns all the LLCs and collects the rent for all the rental properties. Now, think about it. After all, if you hired a management company to manage all your properties, you wouldn't need to hire a separate management company for each property, right? So likewise, using one holding company to collect the rent from all the properties. That way you have a simplicity of accounting and simplicity of rent collecting, and you can use accounting software to differentiate the profit from one property to the next. Wyoming LLCs are a favorite because they offer strong charging order protection, privacy, and minimal reporting requirements. So we set up our holding company in Wyoming, and that holding company both owns the other LLCs and collects the rent. So in summary, we use land trusts for anonymity. Again, you hold title to each property in separate land trusts with a land trust owned by an LLC, or more technically, an LLC as the beneficiary of each land trust. So land trust, land trust, land trust, and LLC, LLC, LLC as the beneficiary of each land trust. So separate land trust and separate LLCs for each property. So this adds layers of anonymity to each property and keeps your name off the public records. And then we set up a Wyoming holding company up here to both own the other LLCs and collect the rents for all the properties. So that's a good foundational protection. But for high net worth investors with equity on the line, it's not enough. And here's why, which brings us to point number 5, the limits of domestic structures. Now, LLCs work great until a judge decides they don't. In a worst case scenario, a judge can pierce the corporate veil and come after your personal assets, issue a charging order against the LLC distributions, like we've seen happen to people who called us, who eventually became clients. So they can seize domestic bank accounts connected to your real estate. If you have properties that have significant equity, you need more than corporate formalities. You need to make the equity disappear legally. And that's where the next tool comes into play, the Cook Islands Trust and equity stripping. Okay, point 6, the offshore trust and why it works. Now, the Cook Islands is considered the most powerful asset protection structure in the world, bar none, because the Cook Islands law does not recognize U.S. court judgments. To attack assets in a Cook Islands trust, a creditor would have to hire a local Cook Islands attorney, no contingency fees allowed, pay a massive sum up front to that attorney, like $100,000, for example, up front to the attorney, start the lawsuit from scratch and win beyond a reasonable doubt, even in a civil case. And that's nearly impossible to do. But here's the key. The Cook Islands Trust doesn't directly hold the real estate. Here's why it doesn't. Because U.S. courts have jurisdiction over U.S. land and real estate, and a judge can ignore the trust and seize the property anyway, unless we use a strategy that changes the game, which is point number 7, equity stripping, the real shield for rental property. So this is the part most asset protection gurus get wrong. If you hold your title of your rental properties under a Cook Islands LLC, a U.S. judge can seize them. That's why we don't rely on ownership. We rely on debt, on stripping that equity. So here's the strategy. We record an equity line of credit mortgage against your property payable to a Cook Islands LLC, and that Cook Islands LLC is owned by your Cook Islands Trust. So this lien strips the equity out of the property on paper, but no money changes hands. Yet, if a lawsuit becomes real, a third-party lender, one of our trusted financial partners, can purchase that mortgage. The lender sends the loan proceeds to your Cook Islands Trust structure in a bank account in the International LLC. So what's the result? The equity is gone. The property is heavily encumbered, and the proceeds are sitting offshore out of reach, say in a Swiss bank account, for example. some of the safest banks in the world. So even if a court rules against you, they'll find that the property is fully leveraged with no equity to seize. So that's how equity stripping works. And that's one of the few ways that actually works under a U.S. jurisdiction. Okay, point number 8 in this talk we're having here is here's a case study. Real estate developer in Texas as an example. So let me tell you about one of our clients. We'll call her Sarah. Sarah owned 5 rental properties across Texas with a combined equity of $3.7 million. She had all the properties in separate land trusts with LLCs as the trust beneficiaries, but a disgruntled contractor was threatening to sue after a failed rehab project. So what we did is we set up a Cook Islands trust with the Cook Islands LLC inside of it, and then we recorded equity line of credit mortgages from the Cook Islands LLC against each one of her properties, leaving a thin layer of equity visible for operating purposes. So our third-party lender purchased the mortgages and then put the proceeds into our offshore trust. Now, when the contractor's attorney pulled the property records, they saw heavy liens on all 5 homes, and within 90 days, the attorney walked away. They wanted a payday, not a legal war in the South Pacific with nothing to gain. So that's protecting real estate the right way with equity stripping. Okay, now that brings us to point number 9, which is a question, what about contempt of court? And this comes up all the time. Can a judge order me to bring the money back? So here's the truth. Yes, a judge can order you to repatriate assets, but under our trust structure, you can't comply, and that's by design. The trust that we set up, we include a duress clause. When you're under legal duress, that means the offshore trustee company law firm is legally barred from following the instructions if you're under court pressure. So you can get the money anytime you want under your own free will, but your legal entity cannot. Now, since our licensed, bonded, regulated trustee company has stepped in to protect the assets at that point, the courts cannot hold you accountable for what you can't legally do. So that's how asset protection trusts work. A licensed bonded trustee can step in to protect you when needed. And I can say, as somebody who's been setting up Cook Islands trusts for 30 years, it is the most regulated trust jurisdiction in the world as part of New Zealand. You look up Transparency International, the Global Corruption Perception Index, and New Zealand has ranked one of the top most trusted countries in the world for trustworthiness. And Cook Islands is part of New Zealand. So this structure isn't just theory. It has been tested in court and has protected our clients each time we've employed it. And like I said, we've set up more Cook Islands Trust than anybody in the world, so that's saying a lot. Point number 10, protecting cash flow and ownership. Probably what you want to hear about. So let's tie this all together. Here's a complete protection structure and what it looks like for rental property. So the property is titled in a land trust to keep your name off the public records. Each land trust is owned by a separate LLC. All LLCs are owned by a Wyoming LLC, and that equity is encumbered with a mortgage payable to a Cook Islands LLC. The Cook Islands LLC is owned by your Cook Islands Trust, right? So you manage the Cook Islands LLC as long as there are no legal threats. So if a lawsuit strikes, the offshore trust company steps in to protect you. So this setup does 3 critical things. 1, it keeps your ownership anonymous. 2, it blocks equity from being seized. And number 3, it moves loan proceeds offshore if needed. It's the most powerful combination of domestic and offshore protection that exists, bar none. Point number 11, the cost versus risk. Now, let's go ahead and talk numbers. Setting up a Cook Islands Trust with a Cook Islands LLC, equity stripping mortgages, and ongoing support typically costs about $25,000 to $35,000, maybe a little more if you have a lot of properties. Now, that's not cheap, but losing property to a judgment isn't cheap either. We've had clients who were facing $2 million lawsuits and walked away with their assets untouched because they acted before the lawsuit hit. And that's the key. You're way better off act before you're sued, and you're also going to save a lot of money by acting before you're sued as well. So point number 11, what happens after setup? So once your plan is in place, we continue to support you. We help you maintain your structure. We help you file annual renewals and coordinate with third-party lenders if a threat arises. So our clients often tell us that just having the plan in place gives them a new level of peace. So here's the benefit. You stop looking over your shoulder. You stop worrying about losing what you've built. And as a result, you make way more money because you're looking forward to your next deal and not backwards at the legal attack. And that's what real asset protection gives you: freedom and peace of mind. So here are our final thoughts. Point number 12, be the one who thinks ahead. So let me leave you with this. You can build a fortune through rental properties, as you know. But one legal misstep, just one angry tenant, one lawsuit-hungry attorney, and it's gone, possibly all gone. Asset protection isn't for people who hope nothing bad happens. It's for people who know bad things happen and plan accordingly. I mean, think about your houses. What do they build first when they build a house? They build the foundation. The same thing here. You should build your foundation on a solid platform of asset protection. That's how you want to build your wealth, on a solid foundation, and you build your wealth on top of that. So don't wait for a lawsuit. Don't rely on insurance alone, because we've seen insurance fail when people are sued for more than their coverage, when there's one exception in the policy, or you're sued for something your insurance doesn't cover. And don't believe that your LLC is bulletproof. It's not, and we've seen it not be bulletproof. So if you want to protect your properties, your income, and your peace of mind, you can feel free to visit us and get more free information at assetprotectionplanners.com, where we've helped over 100,000 clients shield their wealth, and we can help you too if you're serious about protecting yourself. So I hope this has opened your eyes to what's really possible and what's really necessary if you're serious about protecting your rental properties. If you got value from this, hit the like button. Subscribe if you haven't, and share this video with somebody who needs it. I'm the Business Guy, and thank you for watching, and I'll see you in the next one.